Hello students. Be ready for the dictation. Start. 5. Having heard Shri Alok Sangwan, learned AG, appearing on behalf of the state, and Shri Neeraj Kumar Jain, learned senior advocate, appearing on behalf of the original writ petitioners in civil appeal arising out of CWP number 16346 of 2013 before the High Court, and having gone through the material on record and the manner in which the state has dealt with the acquisition proceedings and has released the lands acquired from time to time right from the proceedings at the stage of Section 5A of the Act and thereafter is highly depreciable. Earlier the lands have been released by the state government initially in favor of the influential persons and thereafter pursuant to the various orders passed by the High Court which were never challenged by the state. It demonstrates the arbitrary exercise of powers by the state in releasing the acquired lands which as such required for public purposes. At the outset, it is required to be noted that when the lands are acquired for the utilization and development as residential and commercial area to develop new sectors and that too by the Urban Development Authority, the future need is required to be considered and the expansion in future is also required to be taken into consideration and or bear in mind. The expansion in future in the next 20 to 25 years is required to be taken into consideration and or is required to be considered when use of such a vast land for the development of the area new sectors are required. In the present case, it is not in dispute that large chunk of area measuring 46.49 acres was acquired as far as back on 21 April 1987. Such a large chunk of land was acquired for the development and utilization of land as residential and commercial area in Sector 11, Kurukshetra by the Haryana Urban Development Authority. Out of 46.49 acres of land acquired, wide notification under Section 4, 10.83 acres of land came to be excluded from acquisition at the stage of notification under Section 5A. Out of remaining 35.66 acres of land, 1.05 acres of land was released between Section 6 notification and the award. Thereafter, out of remaining 34.61 acres of land, 26.83 acres of land came to be released after award dated 12 April 1990. Therefore, the balance land remained to the extent of 7.78 acres only, out of which even at present approximately 6 acres of land acquired is under litigation. Therefore, the land with respect to the original writ petitioners of CWP number 16346 of 2013 is only small plots of the land which remained. If the map produced on record is considered except the present small portion in question, all other major chunk of the land, the particulars of which are given as above, have been released either by the state on its own and or pursuant to the order passed by the High Court which were never challenged by the state, and it seems that the state was happy with the decision of the High Court directing to release the lands from acquisition. In the earlier order passed by this court in Civil Appeal number 3235 of 2015 with respect to the lands acquired by the very notification, it appears that this court took note of the release of the lands by the state government upon refund of compensation. This court took note of the fact that several landowners whose lands were acquired filed writ petitions challenging the notification, which writ petitions were however withdrawn with liberty to file representations with the state government, and thereafter, the representations were answered in favor of the writ petitioners by ordering release of the land after refund of compensation. Therefore, this court in the case of Vipin Jindal, Supra, also relegated and permitted the said landowner to file a representation by observing that somewhat inconsistent stand has been taken on the part of the government. That thereafter, the representation of Vipin Jindal has been considered favorably and his land has been released from acquisition. Even from the judgment and order passed by the High Court in CWP number 11377 of 1988, by which the High Court allowed the said writ petition and quashed the acquisition with respect to some of the lands acquired by the said notification, it appears that what weighed with the High Court was after the notification under Section 6 of the Act. The government withdrew from acquisition some of the area which belonged to the then Speaker of the Haryana Vidhan Sabha and another portion belonging to the Radha Swami Satsang, Kurukshetra. Para change. 6. Thus, from the aforesaid, it is apparent that earlier except the land in question belonging to the writ petitioners of CWP number 16346 of 2013, all other lands have been released except the small parcel of the land belonging to the original writ petitioners. Now, non-release of land is sought to be justified on the ground that the same is now proposed to be used as shopping mall and parking. It is required to be noted that the land in question has been acquired in the year 1987 along with the total land measuring 46.49 acres, out of which, except the present small parcel of the land, all other lands have been released and or the acquisition with respect to same have been quashed. Considering the aforesaid facts and circumstances, when the High Court has allowed the writ petition and has quashed the acquisition proceedings and has directed to release the land in question, it cannot be said that the learned single judge and or division bench of the High Court has committed any error which caused for interference of this court. No interference of this court is called for. However, at the cost of repetition, we deprecate the manner in which the state has dealt with the acquisition proceedings and have released the land and or permitted the acquisition to be quashed in a most arbitrary manner. The lands as such were acquired for the residential and commercial development purposes which could not have been utilized and used for public purposes and development of the area, and the state government by exercising the powers arbitrarily and or in favoritism has failed to use the lands for public purposes for which the lands were acquired. The state government is guardian of the public interest and the public interest was required to be considered the paramount interest rather than releasing the lands at initial stage in favor of the influential persons. The state shall take care in future and must use the lands acquired for the purpose for which the same have been acquired, otherwise the object and purpose of acquiring the land will be frustrated. Now, so far as the civil appeal arising out of CWP number 10452 of 2014 is concerned, at the outset it is required to be noted that the land in question is already utilized and used for the sewage lines and approximately 17 crores rupees have been spent in constructing sewage lines. Therefore, the High Court has committed a very serious error in quashing and setting aside the acquisition with respect to the said land which is already put to use for the sewage lines which is being used for the public purpose and for the residents of the locality. Thank you, students. Over.